Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Michegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. A cupcake sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Welcome back. Welcome back to those of you who were with me this morning. We did a couple of hours, on the new motion filed on Karen Reed by Cosgrove to extract her phones and commence a team to go through Karen Reed's phones that were seized in January 2024 when they tried to indict Karen Reed and Aidan Carney together on conspiracy to intimidate witness charges. That grand jury did not indict. And so Cosgrove's looking for a second bite of the apple. But what I want to know is, when was Cosgrove appointed special prosecutor for Karen Reed? I have so many questions. None of them were answered this morning, except we did find some very interesting information on the series of unfortunate events that led to Aidan Carney going to jail in December of 2023 and the timeline there. So if you didn't watch it, my hair is full of secrets. It's a Dyson Airwrap. And they're starting the Zoom right now on Brian Walshe, Miles King, et al., and all of the other cases affected by the Proctor communications that were turned over in the Karen Reed case that they've been trying to get forever. And remember, Rosemary Scapicchio, our spirit animal, they started an evidentiary hearing and she had Lally on the stand and she was just starting to get into some of the really good stuff. And then the judge just called it off. And now we're back in the land of the lost, trying to get these Proctor communications. It's insane. It's crazy. Check out these awesome sunflowers that I got. I just set them up when I went downstairs in between streams. Oh, well, they're really heavy, but they're pretty awesome. And highly recommend. The way to go to Boston from Long Island is to take the ferry. And on the way home, I took the ferry from New London to Orient Point. And those sunflowers on the side of the road at a farm stand had like 100 bouquets. And it's just $10. Just put it in the box. Not even anybody there manning them. $10. Just put it in the box. We trust you. No worries. No worries. And then next time there's a bouquet of like dahlias that I got at another farm stand called Briarmere Farms. Highly recommend also. They're famous for their pies. And my daughter requested a coconut meringue pie, which I happily bought for her on my way home. They're awesome. Briarmere Farm. Do I have any Long Island viewers left? I mean, I remember when I was covering the Long Island serial killer case, I had a lot. But if there's anybody here from Long Island, shout out to my people. And New London, Connecticut is here. Hello, New London. Hi, Barry Adams. I go by you a lot. Because when I take the ferry to Orient, that's where I go. There's also a Block Island ferry out of New London, isn't there? I believe that there is. Because those of you might not know that Block Island is really a real place. It's a real place. And it is an island. It's technically part of Rhode Island. But it is in between Montauk, Long Island. Oh, Jenny's from Long Beach. Yay, Long Beach. Montauk, and you can take a ferry from a part of Massachusetts, and you could take a ferry from Montauk, you could New London, and there might be one from maybe Newport, Rhode Island, or somewhere like around there. But Block Island is a beautiful place. It's kind of lost in time and stuff like that. Rhode Island is in the house. Yay, Rhode Island. All right, so we're here for the hearing that is supposed to be starting in courtroom 25, which is Judge Krupp's courtroom at 2 p.m. There may be a couple of other cases on the calendar, but we don't care. We'll watch them all. We're hoping that Rosemary Squiscio, she'll be there. Brian Walsh will be there on Zoom. And sometimes they like to put his face just center stage because he's so creepy. And I don't know, feels like he's watching us. He got stabbed the other night in the Norfolk County Pokey. Brian Walsh did. And apparently it wasn't very serious because he was just treated and released from the local hospital. Turns out it was some sort of dull shank. We don't know who did it, but he got stabbed apparently in the head. All right, Long Island is in the house, G-Laz. Yes, oh yes, oh yes, oh yes. Mother of Men, hashtag Mother of Men. Your son has a summer house in Newport, Rhode Island. I heard that might be where Travis and Taylor are going to be getting married, at her house in Rhode Island. I'm not sure if it's in Newport, her house, but she's got an amazing spread there. I found out the address and I have to Zillow it. Zillow for me is like my corn. You can't say the P word. So Zillow, I stalk Zillow all the time because I just love to look at houses and the insides of houses and old houses. And sometimes I'll do a deep dive. And what I'll do is I will, we have a lot of old on Long Island. We have a lot of old Gold Coast mansions because Long Island was the place that the Vanderbilts would summer, and the all the really rich JP Morgan family would summer, and a lot of very, very wealthy New Yorkers, if you watch Gilded Age, you know what I'm talking about, had their summer homes here on Long Island. The Vanderbilt Mansion is one of them, and it's beautiful. Yeah, I already went over it. Thanks, Michelle. I went over the audio on Kelsey's hearing. I did it. We did the audio. It's in the same stream with the Wilbur recap, which I did on Saturday right after I got home from Massachusetts. And it's in that stream. It's time-stamped for you. So if that's the only part you want to listen to, you can go right to that part. And yes, Michelle, we did. I have also sent for the audio on the Josh Hubert trial because it turns out 3 men were tested. 3 men were tested for the seminal DNA. Yes, we covered Bradel's motion to reconsider. We did. We did that last week. Guys, you got to keep up. You got to keep up. We're on top. We're on top of this. Like, you don't know. Kelsey Fitzsimmons' favorite color is purple. So for anybody that's going to turn up to support Kelsey Fitzsimmons, please do so. October 7th at the Salem Courthouse. Isn't that so fitting? I'm gonna do here. If you are at home and you are on the Zoom, please mute me. Please mute me because it's happened before and people hear my voice and they think I'm the one who didn't mute.
Court's now in session. You may be seated.
Can we have Mr. Johnson brought in, please? You are on a starting today with the Commonwealth versus Miles King, indictment 2021-0320. Mr. King is represented by Attorney Rosemary Squiscio. Bianca Ciancio, indictment 2022-0265. Ms. Ciancio is represented by Attorney Joe Cataldo. Giovanni De Los Santos, indictment 2022-0267. Mr. De Los Santos is represented by Attorney Joe Kowski Jr. Sean Johnson, indictment 2022-0268. Mr. Johnson is represented by Attorney Rosemary Squiscio. And Commonwealth versus Brian Walsh, indictment 2023-0091. Mr. Walsh is represented by Attorney Larry Tipton and Attorney Kelly Porges. Counsel for the Commonwealth is ADA Lisa Beatty, and is this Blair with you?
Well, good afternoon, Your Honor. Lisa Beatty for the Commonwealth. I'm present for the first part of it, and then to the extent that the individual cases need to be addressed today, the individual assistant DA is assigned to the trial team will appear.
Great.
And Judge Rosemary Squiscio, on behalf of Mr. Johnson and Mr. King, I'm also standing in for Joe Kowski Jr., who's on trial in front of Judge Dupuy down in Fall River. And I believe that Joe Cataldo's
client was excused.
Yeah.
And I indicated that if he could not make it, I would stand in for him as well, Judge.
All right. And I think Mr. Tipton indicated that he had some issue today, and
Happy to stand in for Mr.
I think
Tipton.
he was,
I thought he was going to be on Zoom.
do you think he was going to be on Zoom?
Oh, okay.
Oh, Joe, Mr. Cataldo's walking in,
Okay.
but I thought that either Mr. Tipton or Ms. Porges was going to be on Zoom.
I'm not seeing either one of them.
I'm happy to stand in and report, Judge.
Okay. Ms. Beatty, where do things stand?
Your Honor, I can report to the court that we have completed our review and we are in continued conversation with the U.S. Attorney's Office. I recognize that that's not a lot of information to provide to the court, but that's the extent of the information that I have for today.
Have you come to a conclusion that certain information supplied in the confidential information should be turned over in these cases?
All I can say is that we are in conversation with the U.S. Attorney's Office as a result of our review.
All right. Well, your review is the threshold for having conversations. So if you're having conversations, it must be that you have made a determination that certain information needs to be turned over. And what am I missing? There's no hide the ball here. If you think that certain information should be turned over, you would have conversations with the U.S. Attorney's Office and maybe would have to go to the court if the U.S. Attorney's Office doesn't acquiesce.
Because of the order, I'm reluctant to comment further in open court and at this stage. And so on the advice of counsel at this point in time, that's the statement that I feel comfortable giving. In no way am I implying to the court that I will refuse to provide further information at any point in time. Just for today's purposes, that's what I feel comfortable disclosing to the court.
I don't recall any provision of the order that would bar you from disclosing whether you think anything contained in the confidential materials should be disclosed. Maybe I missed it, and I didn't go back for purposes of this hearing to review, but you were authorized to do the review, but I don't think you are barred from sharing whether you think certain information, not what the information was, but that there existed among the confidential materials certain information that should be turned over in certain cases. You read the report differently, the federal order differently?
So there's a series of orders, and I'm just trying to be cautious. If you want to give me a second call, I can consult with our counsel. But I guess my question to the court also is depending on, how fully we answer that question at this point in time, I'm trying to figure out what the next steps are for this court's purposes.
Right. If you answer the question, we've reviewed the documents and there is nothing contained in the documents that needs to be turned over, that's one response, and that's one response that this court will have in terms of scheduling. But if your response is there are certain things that should be turned over, that's our assessment, then under the federal order, you'll have to go to various places to get authorization. If you're doing that, defense counsel would have an interest in seeking to join that effort to liberate the documents for disclosure. And so that's why your initial assessment, which I don't think is covered by the confidentiality order, protective order issued by Judge Casper, the most recent iteration that liberalized it and allowed you to do this evaluation, I don't think it covers that threshold question of yes or no, not the substance. So I'm happy to put it on for a second call. You can take a look. Everybody can take a look at the order because everybody subject to the protective order has those orders now. And you can have a discussion about that if you like.
I agree with the court in terms of the interpretation. I thought we were here today because the Commonwealth was taking that initial look. That's why we gave.
They did take the look, and that's what Attorney Beatty is saying, that they have taken the look, but at least the threshold question she felt right now uncomfortable telling us whether it was the Commonwealth's view that certain information should or shouldn't be turned over to the defense. I haven't gone back to look at the order. You folks should. You can actually compare interpretations if you want, have a discussion, and then I'll see you again.
Thank you.
Second call.
Matters held for further call.
All right, second call. This will be interesting to watch other cases to see what other BS Judge Krupp has to deal with today. That was Lisa Beatty and the other female attorney, Rosemary Scapiccio, who was standing in for just about every other attorney.
Number 5 on the list, Commonwealth versus Tatiana Cosme, indictment 2021-014, scheduled for an initial probation surrender. Probation is
2021.
represented by P.O. Rachel Boyce. Attorney Invillatos has been kind enough to say he will step in and represent the defendant. Counsel, Madam Officer, if you could identify yourself, please, for the court and the record.
Good afternoon, Your Honor. Rachel Boyce with probation.
Okay,
Good afternoon, Maki Anzalatos on behalf of Ms. Cosme, and I'll accept the appointment.
thank you. We will appoint CPCS for that.
I think this is on, I don't know if there's been an initial, I do want to raise a probable cause issue.
Let me just see if I can understand what's going on here.
Sure.
I can explain it, Judge, if you're...
Cosme is on probation for a trafficking charge, or?
I think she's on probation for the conspiracy.
Oh, conspiracy charge, okay. And she recently picked up a new charge of larceny over $1,200.
Correct.
And that was, looks like it was arraigned in August, early August.
Yes, Your Honor.
All right, what do you ask me to do?
We were here August 14th for an initial surrender hearing, but we could not go forward that day because there was no duty attorney available. So today we're back here for an initial surrender hearing. I'm asking that she be released on personal and we get a 30-day date to come back.
Mr. Anzalatos?
So I just got the paperwork today. I did want to be heard on probable cause. I could either make an argument today, or we could pick a date for further initial where I could file something. The short version is, if you read the application for complaint in the new case in Dedham, and it hasn't been subject to a de Benedetto proceeding there yet, as far as I can tell from the docket. I don't represent her in Dedham. There was a bail posted actually in the case that my client's on probation for. The bail slip was in her name. She retrieved the bail. Her ex-boyfriend, who's also the co-defendant in the drug case, family member, mother, is accusing her of taking that money when in fact it was the mother's money sort of lent to her to post bail. If you actually dig through the statement of facts, what it sounds like really happened is that the mother went to the police station to bail both of them out, couldn't stay and wait for the bail commissioner, and allowed the slips to be put in their names. Based on my understanding of the law, at the moment that she's handed the money over and put it in the name of Ms. Cosme, that slip, for all intents and purposes, becomes a bearer instrument. It's like signing over a money order, or signing over a check, or signing over everything. I don't actually believe any of the allegations, but even if the allegations in their entirety are believed, it's a civil matter. She lent money to someone and that person is allegedly not paying her back. That's not larceny by any stretch of the imagination. And in fact, Ms. Cosme, I'm sorry, not Ms. Cosme, but the complainant, in somewhere in the back of her head,
Larceny is what? The taking of property belonging to someone else with the intent to permanently deprive the person of the property, right?
Well done,
Someone
Judge.
gives you their property and says, well, you give it, you have to pay me back. That would mean every loan that was unpaid is a larceny. It's just not, which is why the complainant has an ongoing case in small claims court. She knows this.
I think it's glib to say that every failure to pay back a loan with the intent of permanently depriving the money, the other person who loaned the money, of the money, is not a larceny. I think, it may well be able to be charged as a larceny. It may be a civil matter too, but much depends on what the back and forth was between the person who posted the bail and the other person. In any event,
like
I think what we'll do is we'll put this on for 30 days, see if it can be resolved. And if it can be resolved, great. Otherwise, we'll have a hearing. I think we can put this on for a final.
That's
Yes,
fine.
fair enough.
I'm sorry, you told me the days and I already forgot. Monday, Tuesday, and Thursday.
And Tuesday doesn't work for us.
So I can do Thursday the 16th.
Yes,
October 16th?
Yeah.
that works.
Okay, great.
Sure.
Final surrender, October 16.
Yeah.
Thank you.
Okay.
Judge Walker actually resolved
Ms.
cases.
Cosme, Attorney Insulatos has been appointed to represent you in this matter. Your matter is continued to October 16th at 2 p.m. Stay in touch with Attorney Insulatos.
Okay, thank you.
You're all set.
Thank you, Your Honor.
Your Honor, number 7 on the list, Commonwealth versus Charles Martin, indictment 2022-0125. This matter is on for a final pretrial conference. Mr. Martin's present in court with his attorney, George Olson. Have we seen Mr. Olson? Oh, there you go. And Commonwealth by Michael Gaffney, Mr. Olson and his client.
Okay, Mr. Gaffney, I've received a motion to dismiss the indictment.
Yes, Your Honor. One indictment
With
3 counts.
prejudice?
Yes.
Any objection?
No, Your Honor.
Anything else holding your client?
No, Your Honor.
All right, Mr. Martin, you are free to go. I'm granting the Commonwealth's motion to dismiss the indictment with prejudice.
What?
Okay,
That
Thank
never
you.
happens.
all right.
He just dismissed his indictment?
Case dismissed. Number 8 on the list, Your Honor, Commonwealth versus Tasha Hayes, indictment 2022-0159. Mr. Nelson was kind enough to say he'd accept appointment on this matter. Commonwealth is represented in this matter by ADA Joe Martinelli. Mr. Nelson and ADA Martinelli are present in court, as is Ms. Hayes. Counsel, starting with the Commonwealth, kindly identify yourselves for the court and the record.
Good afternoon, Your Honor. Joe Martinelli from Commonwealth.
Okay, Mr. Martinelli.
Robin Nelson in this case.
Okay, Mr. Nelson. Mr. Nelson, Mr. Silverman had represented Ms. Hayes. There was an issue with respect to their ability to get along, and I appreciate you being willing to take the representation. Ms. Hayes is scheduled for trial on the 23rd. Is that right, or next week? I guess
It was originally tomorrow.
Oh, it was originally tomorrow. I'm sorry, tomorrow. And this is an old case, so we're going to put this on for trial sometime very soon, after you've had a chance to get up to speed. So I'd like to set a trial date, understanding that you haven't gotten, maybe you have. Mr. Martinelli, have you provided the discovery to Mr. Nelson?
Not as of yet. I can get it to him by the end of the day.
Okay, great. So we're going to schedule a trial date sometime soon on this. What I was thinking is we put it on for a couple of weeks
That's fine.
from now to set the trial date, but it'll be before the end of the calendar year. So when will you be back? What's convenient for you in terms of coming back? Before the end of the month. How's the 25th of September or 26th?
I'm not available the 26th. I would be available the 25th.
24th?
Oh, the 25th is a problem. 24th will not work. Actually, the 26th isn't going to work either. How about the 29th?
I'm away that week.
You're away that week. How about the 22nd?
Could be.
Monday, the 22nd?
Sure.
Okay, great. 22nd at 2 p.m. You'll have to be back at that time, Ms. Cosme, and we'll be picking a trial date before the end of the calendar year. Okay?
Okay.
Very good.
Is that trial assignment?
It'll be for trial assignment, yes.
Matters continued to September 22nd at 2 p.m. for trial assignment. Thank you, Mr. Nelson. Thank you, Mr. Martinelli.
Thank you.
Your Honor, number 13 on the list, Commonwealth versus Marcus Isidore Souza, indictment 2023-0307. Mr. Souza is present in court. He's represented by attorney Sarah Westra, Commonwealth by ADA Emily Farley. Counsel, starting with the Commonwealth, please identify yourselves for the court and the record.
Good afternoon, Your Honor. Emily Farley for the Commonwealth.
Okay,
Good afternoon, Your Honor. Sarah Wester for Mr. Souza is present tonight.
okay. Go ahead. Where are things?
Your Honor recently issued a ruling allowing counsel's motion to suppress with respect to indictments 002 and 005. In light of that decision, the Commonwealth entering an all press on those 2 indictments.
Oh, he's
Okay.
charged with cocaine
And,
trafficking.
The other counts, 1, 3, and 4?
The Commonwealth's able to proceed on those.
Okay. So we just need to schedule a trial date?
the motion.
Witness intimidation, too.
Motion to suppress date. There are two additional motions to suppress that were unrelated to the motion to suppress that we already litigated. One has to do with the,
We litigated things piecemeal?
if
Doesn't sound like my style.
100
certainly are.
grand
We
more.
filed the motion to suppress, that Your Honor heard, to be able to move the case along. In the meantime, getting the poll camera footage, took a while. I obtained it. It's a 30 days of surveillance video.
So when did you file this motion to suppress?
If the court wants to, I was speaking with the Commonwealth about either selecting a filing date.
You haven't filed the motion to suppress you're referring to?
That's correct.
Oh, okay, all right.
He's charged with between 100 and 200 grams of
So there's two motions to
cocaine.
suppress that need to be filed. The primary one is requesting a Frank's hearing, based on the poll camera footage, the warrant that they obtained.
With intent to
and a separate
distribute.
Motion to suppress, which is just a standard four corners motion to suppress that I realized also needed to be filed while I was drafting the request for the Frank's hearing and that motion to suppress. So that's where.
All right, when did you get the poll camera footage?
It was a few months ago. I went personally down to the DA's office and picked it up. Then I needed a PC, and it's a few months ago, Your Honor. I don't have like the exact date with me, but
right.
I have gone through it all. And I'm very close to finalizing the Frank's hearing motion to suppress. But as I mentioned, I also realized, well, in the process of drafting that, I need to also file a four corners motion to suppress the original warrant, because there were 3 warrants. And that I can have that accomplished.
When do you expect to file that?
I would like to have them filed by the end of this week.
Okay.
Ideally.
I'm going to set a schedule for that. So I want to know realistically when you can file the motions that you're referring to, because it's my general practice to litigate all the suppression motions at one time. I understand things happen. I understand things trickle out. And but let's schedule it for hearing, for filing and a hearing date soon after for anything that we've got to hear.
May I have September 30th for a filing date?
For filing, so that's
It's the way they always do it on Zoom. They only have the camera on the judge. I don't know why. I don't set up the cameras. I would absolutely have
September 30 for filing.
Camera on the attorney, but.
And let's get a hearing date.
It's just the way they do it in Norfolk County. It's this guy.
October 17, this will be non-evidentiary.
Marcus Sousa charged with cocaine, trafficking in cocaine.
Entire week.
1, 2,
Okay, 20th?
3 counts of intent to distribute.
21st?
And witness intimidation. Yes, they do actually charge other people with witness intimidation.
At 9 a.m. or 9 a.m.?
The 21st, we're talking at 2 o'clock.
I can do the 21st at 2.
21st at 2, non-evidentiary. Motion to suppress of 1 4 corners.
Your Honor, is it possible to do the 22nd, 3rd, or 4th?
The defense attorney is
Yep.
Thara
We could
Westra.
do the 22nd.
That's fine. But Judge, as far as the hearing, part of the motion to suppress, I'm requesting an evidentiary hearing on the Frank's motion.
I'm sure you are, but there's a threshold you have to meet, and so that'll be for why we're scheduling that hearing, okay? So everything that we have to resolve at this first hearing will be on the papers. And I'll take a look at the papers and we'll figure out if we need an evidentiary hearing and we'll schedule it. Okay? Which is one of the reasons why I could do a hearing well before the 22nd. If you're going to file these papers by the 30th, we could do a week later. What do you think?
I'd like a couple weeks to look at it.
Okay, so we'll leave it on the 22nd because you're going to be away somebody's going to be away that week. So 22nd at 2 o'clock for a hearing on the 2 4 corners, 1 4 corners motion and a Frank's Non-evidentiary.
May Mr. Souza's presence be excused on the filing date?
I'm not even going to have the filing date. It's an out-of-court
It's just a
filing
deadline.
date.
Understood. Thank
It's a deadline, but you're setting it, so you've got to meet it.
Frank's motion is when you're alleging that the police officer who signed the
Okay,
search
anything
warrant
else?
affidavit lied
All
to
right,
get
we
the
will
search
see though on
warrant.
the 22nd of October at 2, okay?
Matters continued to October 22nd at 2 p.m. for hearing on a request for a Frank motion and a non-evidentiary motion to suppress. Thanks, everyone.
Thank you, Your Honor. Thank you, Madam Clerk.
Your Honor, number 15 on the list, Commonwealth versus John Emmanuel McNeil, indictment 2025-24-0232. That is on for a pretrial hearing. Mr. McNeil is represented by Attorney Rich Neely, who I have not seen today. And the Commonwealth by 88 Adam Stewart. Don McNeil? Oh, great.
McNeil, Mr. Stewart,
I'm
okay.
scheduled for a pretrial hearing this day, Your Honor. Counsel, starting with the Commonwealth, kindly identify yourself for the court and the record.
Good afternoon, Adam Stewart for the Commonwealth.
Okay,
Richard Neely from Mr. McNeil.
all right. Mr. McNeil, you're welcome to sit if you want. You don't have to stand through the hearing.
Breaking and
Mr.
entering
Neely, are
into
there
a
any
building.
motions that have to be heard
Nighttime, 3
Today, no.
today? What's the
charges
story in terms of discovery?
and larceny from a building.
Sorry, go ahead.
So
Breaking into a
discovery from the
depository,
Commonwealth's
that's like a
perspective
bank.
is just about complete. There is Your Honor may recall on the last date, there was potential privilege information identified on the cell phone extraction of the defendant. And so I had filed a motion for a protocol to handle that. Recently, there was some issues with defense counsel being able to access the files. So I worked with him through those tech issues. And he recently filed his privilege log related to the cell phone extraction. It's a handful of what appears to be, from what I can gather from the pleading, reference to call log entries on the cell phone, as best I can tell. I don't
This
have
is
any
Norfolk
issues
County.
with those being
Norfolk.
segregated and a new extraction completed. But I obviously can't look at the phone to see what those entries are under the current protocol. So I don't know how the court would like to proceed as it relates to those.
Did I issue an order establishing a protocol?
So there was a protocol through which defense counsel would file a log
Something
along
that
with
I
any
signed?
item.
No, I didn't
Correct.
approve the protocol?
No, it was
Correct.
Judge Halal, who's
Judge Halal did.
Oh, was it? That's right.
Okay,
My apologies. And so under the protocol, defense counsel would review, produce a privilege log along with copies of those items. We have the log. I know Attorney Neely indicated in his pleading he wasn't able to extract the items. But I think we essentially can stipulate that those items for now are privileged and I can have them extracted and have a new extraction redone, removing those items.
so why doesn't that solve the problem? You don't need access to them. You're stipulating that they'll be removed and you won't have access to them.
Correct.
Okay. So
But
all
under
the-
the current protocol, it was the court would have to order that they are privileged after reviewing them. But obviously the protocol is slightly different given the technical difficulties that defense counsel has had.
Sue, can I trouble you for that order if we've got it? In the McNeil file.
The order should be paper 8,
Paper 8?
I believe so.
A lot of new members today. Welcome. If you don't want to join to get special emojis, all you got to do is subscribe. That's free. Thank you, Cookie Doodle. And hey, it's me. Look at Kelly Applegate with a $50 super chat. Again, lots of little flower stands here in the Pacific Northwest. Snohomish County with the little money boxes outside for the honor system. They have a lot of them out east too here. For those of you who have never been to Long Island from Massachusetts or Connecticut, it's so easy. Just take the ferry. It's a beautiful boat ride. And there's so many, I'm eating Uncle Frank's grapes, yes.
All right, so
Wineries,
I'm looking at paragraph 2 of the
farm
order.
stands.
It says the court will review the privilege log and associated data in camera and make a privilege determination. The privilege log will be subject to a protective order, et cetera. Can somebody turn off their phone? All right. So you're stipulating that the material that's been identified by Mr. Neely is subject to privilege and that paragraph 2 is unnecessary. So assuming that paragraph 2 is unnecessary, and the court will presume, at least for present purposes, that the material that Mr. Neely's designated is subject to a privilege, and you're off to the races, right?
So then I'll have to have the phone sort of filter those out, re-extract it, and then produce a copy to counsel, as well as have one now for myself to actually be able to review.
Right. Any reason that isn't sufficient?
No, it is sufficient.
Okay.
Kelly.
All right. Do I
Applegate.
need to do anything more, Mr. Stewart?
At the current time, as it relates to that issue, no.
Okay. So that's how we'll proceed. I'll presume that what Mr. Neely's designated is privileged, and you're good to go. Then the question is next steps.
Next step would be filing of a motion.
Motion for in what?
Suppress.
To suppress what?
The results of the execution of a search warrant of Mr. McNeil's home.
Because they do that a
Okay,
lot there in
and,
Massachusetts. Thank you,
Is that
Mrs.
a Four
Bouquet.
Corners challenge or?
Yes.
Four Corners? Okay. When do you want to file it?
I'll tell you about a Four Corners
First week in
motion
November.
after.
November?
Yes.
That seems kind of far away.
Last week in October.
You're a tough negotiator. All right. Yeah, let's say filing by October 27, Monday, October 27, out of court date, and I'll have a hearing the week of November 10. How's the 13th?
13th is good for me.
Would that be at 2?
Yep.
Yes, I can do 2 on
Four Corners challenge hearing at 2 o'clock on the 13th.
This guy's charged
Would
with
be on the list for the
3 counts of breaking and
27th
entering
or-
into a
Nope,
building at
that'll be an
nighttime
out-of-court
to
filing
commit a
date.
felony, larceny from that building,
Do I need to make it an in-court filing date?
breaking into a
I
depository,
mean,
which
yeah,
I
you'll
guess is a
file it up
bank.
by the 27th, and we'll have the hearing on November 13th.
Defendant's name is John Emmanuel McNeil. Anybody know him? Somebody
Okay.
said they knew the
All
other.
right.
Now it is continued to November 13th at 2 p.m. for a hearing on a motion to suppress. You're all set, Mr. McNeil. Thanks, everyone.
All
Thank you, Your Honor.
set.
Thank you, Madam Clerk.
All set, Mr. McNeil.
You're on number 17 on the list, Commonwealth versus Caleb Adames.
Oh, let's see what he's
Mr.
got.
Adames present. Your Honor, for the record, it's indictment 2025-0143. It's scheduled for defendant's pro se motion to modify conditions of release. I don't see Mr. Adames present in court.
Good afternoon, Your
Oh.
Honor. William O'Driscoll, the Commonwealth.
Okay?
This was scheduled last week at the defendant's request. I received a phone call this morning from P.O. Flanagan saying he spoke with Mr. Adames, and Mr. Adames indicated he was unable to make it today as he did not have a ride.
Okay?
That's all the information I was able to receive from P.O.
Oh.
Flanagan.
Okay. We'll leave it up to Attorney Wayne or Mr. Adames to notify the court and schedule another time.
Thank you, Your Honor.
Okay?
Assault and battery
Very
with a
good. Thank you.
dangerous weapon of a pregnant victim. Assault and battery on a family or household member,
Let's do one of
destruction
them,
of
and then we'll do the
property
other.
over
Okay.
$1,200
Can we
with
have,
malicious
Ms.
intent.
Powers, please?
But don't worry, don't come to court. It's
Ms.
all right.
Powers?
You only probably beat up your pregnant girlfriend or wife.
Your Honor, for the record, this is number 14 on today's list, the Commonwealth versus.
Come in when you feel like it, sir. Don't worry. We got
Brandy
you.
Lynn Powers. Ms. Powers is represented by Attorney Patrick Kelly, the Commonwealth by ADA Jill Martinelli, docket 2024-0054. Defendants in custody, she's being brought in. Counsel, while we're waiting, if you could identify yourselves for the court in the record, please.
Good afternoon, Your Honor. Again, Joe Martinelli for the Commonwealth.
Okay?
Good afternoon, Your Honor. Patrick Kelly, Ms. Powers.
Okay.
Brandy Lynn Powers.
This is on for a lobby, but I'm not sure it's useful to lobby a case like this. given there are
Possession of a
mandatory minimums.
sawed-off
Do you
shotgun.
folks have any kind of an arrangement or deal?
Not yet. We have discussed a potential resolution, Your Honor, but,
Would it be helpful to lobby with the court?
sure. Yes.
Okay?
She's charged with 4 felonies
Your Honor,
and a
for the record,
misdemeanor.
Ms. Powers is entering the.
Okay, Ms. Powers, counsel has indicated that they had some, thought it would be useful to talk to the court about lobbying the case. So a possible
Where's Court
resolution of the
TV got
case.
their
So they're going
feet
to
up?
come to the sidebar in just a second, and you're welcome to have a seat while we're waiting, while you're waiting.
Court TV, we don't want to see your feed on the Zoom. Like, what is going on? All right, so this chick, oh, shoot. Shoot, I just kicked myself out of the Zoom. did the left swipe. It's all right. They're at sidebar. And we're waiting anyway. Court TV, man, get your act together. So what had happened was, this defendant, her name is Brandy Lynn Powers, is charged with possession of a sawed-off shotgun, carrying a firearm without a license, carrying a firearm without a license that is loaded, two of those charges. No, one carrying without a license, one carrying without a license loaded, ammunition without FID card, possession, and possession of a drug with intent to distribute, Class A felony. And I don't know if they're talking about dismissing her case, but they're doing something at sidebar. The hearing just says it's on for a lobby conference. What's a lobby conference? We'll look it up. The other question is, what is a four corners motion? A four corners motion is a motion to dismiss based on the four corners of the paper, the papers, whatever it is. The judge is not allowed to consider any other evidence or any outside evidence. It's like, if you're dismissing for probable cause, it's based on the probable cause affidavit only. You are dismissing, moving to dismiss based on what's in the four corners of the probable cause affidavit, and nothing else can the judge consider. That's the answer to your four corners motion. But this chick with the sawed-off shotgun, I want to know what's going on with her. This is interesting to watch other cases to see how they handle them, because that other case that we heard before, that was just null pros. They just dismissed the indictment outright. That defendant's name was, oh, did I close that? He was charged with like a bunch of larceny charges. That was the first one, I think, that they dismissed, right? And we can see how a depository is a bank, sweetie. Margaret, a depository is a bank where people deposit their money. That's like an old-fashioned word for depository. I mean, he's awfully nice to this girl who's been caught with a sawed-off shotgun, in my opinion, but, you know. Crazy. Could the depository be an ATM? I suppose. Let's see. I suppose it could. But it was breaking and entering. Or maybe he broke and entered into the bank to steal something from the ATM machine, like he had to get in the lobby. I don't know. They don't give me a lot of details. I just got to try and make it up from what I can see that the charges are. Yeah, Brian Walsh, I guess, is not coming on the Zoom. He didn't show up yet, and I wonder if he's going to have a giant bandage on his head. I wonder.
Matters held for further call.
No, a medical weed is a dispensary, not a depository.
Are the parties on the first call ready for further call?
Yes. Thank you, Madam Clerk.
We're back on Walsh. Rosemary Scapiccio
We're on a
standing
further
with
call on the
everyone.
matters of the Commonwealth versus Johnson, De Los Santos, Chiancio, Walsh, and King. Is that everybody?
I think that is.
He is. Okay. Thank you.
Your Honor, can we approach?
I beg your pardon?
Could we approach?
Yes.
Can we approach?
I don't either.
And that we could discuss that at sidebar.
Okay.
Because we know Melanie Little and Mike Proctor are streaming on YouTube, and we don't want to be embarrassed. We don't want to be embarrassed. Because what we have is lies, 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 yeah, by the Thompson twins. And there's the emoji for that. He's like, oh, I'm looking at the camera. Oh, he's like, smile for YouTube people. Smile for everyone on YouTube. We are outraged. They're trying to hide the ball again. What I found very interesting that Lisa Beatty said on first call was, under the advice of counsel, we don't really want to say anything. Like, what do you mean? You have an attorney? I do know that the attorney that they hired, the Commonwealth, to represent them in federal court is a mentor of Judge Diane Frenier, which is why she had to recuse herself from hearing this. The beeping is a Zoom thing. The beeping is a Zoom thing. It means the Zoom is on hold. Not me, but it sounds like we're in a hospital, right? Doesn't sound like hospital monitors. And that's what it is. The shower curtain is still there. This is courtroom 25, where Karen Reed was prosecuted twice.
Mr. Tipton, to the extent you are on Zoom. Mr. Tipton, are you there?
Court TV putting up their feet.
I don't see him.
Ridiculous.
I've asked him to, oh, there he is.
Mr. Tipton, are you there?
Oh, there, he's here.
Mr. Tipton, are you there?
We see him. I see him. He's right here.
Hang on one second. There you go.
There he is. You're still muted, Mr. Tipton.
This happened last time,
Mr.
too.
Tipton, can you hear me? Just give me a thumbs up if you can hear me. All right, we cannot hear you, but we can see you, and apparently you can hear me. Ms. Beatty.
Shoot, I did it again.
And I decided that there was no reason to have it at a sidebar. So that's all that happened at the sidebar. You missed almost nothing. So let's hear. Oh, there you go. Now I can hear you. That's great. So let's try an open court. What's going on?
And certainly I offered to convey to Mr. Tipton anything that happened at the sidebar, and I will have a conversation with him after court today.
Great.
As can able defense counsel who are present here as well.
Okay.
So before we recessed, the court had posed that there was sort of a binary point at this point in these proceedings, that there was one where the Commonwealth informed the court that they had materials to produce, and one where that they wished to produce, and one where the Commonwealth conveyed to the court that they did not find any materials that they wished to produce. And I'm telling you right now that I am not representing to the court the second, that we do not have any materials to report.
Oh,
I'm
so they
explaining
do.
to the court that we are in communication, and
I think there was a double negative in there.
there was.
You are not representing to the court that you do not have information to turn over.
Yes.
So
you do have information to turn over.
Having done the review,
Yes.
it's worth it for you to go to other locations to try to get information, try to convey the need for you to turn over information which you believe to be discoverable under Rule 14.
We are continuing to have conversations and negotiations with the U.S. Attorney's Office, and what steps we take from there, I don't know at this point in time, but we are working with our counsel at this point in time.
Brian Walsh's
And I'm
trial is
happy to come
October
back
20th.
to court at any time that's convenient for the court, as well as for defense counsel. We're especially mindful not only of the date in the order, but also of the Walshe trial date.
Okay, so we have a return and destroy date of October 21, 2025, and Walshe is supposed to be tried starting around that time, maybe a little earlier than that. So when would you like to be back?
It's Walsh's attorney.
Yes.
I'm just very concerned that we're 25 days into this 60-day destruction order. And I'm concerned that if at some point this board needs to make order, we want to make sure that I just want to make sure that we're giving the Commonwealth enough time to do what it has to do. We can't do what happened initially is, the day before, making phone calls saying this stuff is getting destroyed tomorrow. So I'm just concerned that we're 25 days in, we're 35 days away from the destruction order. And as far as I can tell, we're not very far advanced as to where we were 25 days ago.
Well, 25 days ago, the Commonwealth hadn't reviewed the materials. It had just gotten the order from Judge Casper, and it's now reviewed the materials as it relates to all the cases that are currently before me. And it's made a determination that it needs to go to the U.S. Attorney's Office or the federal court to get authorization to make a disclosure. I think we have had a lot of progress in 25 days. And
To the extent that they can't get that information, Judge, I want some sort of heads up that the federal court said no, or they're not going to do anything. I don't want to be in a situation where we're waiting another 2 weeks and then the answer is no. And now we're behind the 8 ball again. That's what I'm trying to avoid, Judge.
All right, well, in 2 weeks, we will not be behind the 8 ball. In 2 weeks, we will have more information, and I'm happy to revisit this in 2 weeks. That still will be plenty of time before the destruction order, and before October, the destruction order, that would give us 3+ weeks before a destruction order for you or others to go to the federal court to seek additional remedies. So,
So what, we're just going to adjourn Brian Walsh's trial?
Unless somebody thinks so I should put this on for a different time frame, I will put it on for 2 weeks from now.
2 weeks is October 1st. Walsh's trial.
Judge, if I may?
Yes, please
Yeah.
do. Oh.
I would just weigh in and ask that it be put on a shorter leash, a week's date.
What's going to happen in a week?
I mean, what's a reasonable schedule? If you've made the determinations that you've made, you've got to get things on file in the federal court, or those discussions have to be expedited, particularly given the schedule for Walsh.
Either one of those is fine. Obviously, a week is less time to accomplish things than 2 weeks. So if Mr. Tipton wants to come back on his own in 1 week, that's fine also. I appreciate he has a different schedule, perhaps.
Get off your ass and do the work, Beatty.
Than other people. It's really at the convenience of court and counsel.
Get off your ass, Beatty,
Well,
and do the work.
much depends on how much can be accomplished in a week. I mean, have you have the discussions with the U.S. Attorney's Office begun?
Yes.
Okay. And do you think that they're likely to bear fruit in the next week?
Blessed be the fruit.
Do you have a meeting scheduled?
I have found that
deadlines matter.
and that I believe them to be acting as quickly as they are able to respond to our inquiries.
Okay.
But, 5 days is 5 days and 10 days is 10 days. Everybody has lots of different things that they're dealing with.
Sure.
And there's not unlimited time.
You've had this stuff for years.
The 20th.
The 20th. Okay. Let's put this on for the 29th.
I can't do the 29th. I have an all-day evidentiary hearing in Suffolk that involves,
With a real judge who really does the work.
Okay. Can someone stand in for Ms. Capiccio on that
No,
date?
she wants to be here.
I start a trial on the 29th, Your Honor.
You're on trial on the 29th. Okay.
We do the 25th or 26th?
We could do the 25th, but only in the morning. We could do it at noon.
Larry Tipton is not happy.
You have to be in on a final pretrial for the case that I'm starting.
What time's your final pretrial?
2 o'clock.
9 o'clock? Wait a minute, your final pretrial is where?
Suffolk.
Oh, so we could do noon.
Yeah, I'm happy to drive that.
Noon on the 25th?
What day
I
is
could
it?
do noon at 25th.
25th is Thursday.
Thursday, the 25th? Okay, thank you.
May, Mr. Johnson behaved in, Judge?
Sure.
And on behalf of Mr. De Los Santos and Attorney Krowski, I think he would want his client here as well.
Giancio be excused, please.
Yes. Ms. Giancio will be excused. And on the will be 25th at noon.
I thought we said 9 o'clock, Judge, that should be in Suffolk at 2.
I'm sorry?
I thought we said 9 o'clock, that should be in Suffolk at 2.
No, we said noon, and you'll definitely get to Suffolk by 2. Easy.
Depending on how long it takes the ADA to pull her head out of her ass.
Okay, Judge.
Oh, we're going to be on. We're going to be here for 20 minutes, right?
She's
All right.
like,
And 45 minutes now, and we still don't have any answers, so.
All right.
That's right.
Remind me that you have to be in Suffolk at 2. We'll call you right at noon.
I appreciate that, Judge.
Okay.
Thank
All
you, Your
right.
Honor.
Okay.
Madam
Thank you.
Judge. We do have some individual requests for Mr. Johnson that I think we addressed somewhat last time we were here.
What was that?
One of them is Colin's looking for a Rule 17 for the victim's medical records. We don't have any objection to that, Judge. I can't imagine Attorney Krowski has an objection to it, and I know that
No objection.
we don't have any objection. The victim's medical records, they come in, they're going to get them.
It was already filed. Probably impounded. I'll have to go get it out of the walls. I don't have it up here. Do you
I
want it
was just wanted to ask that that motion be heard, on the next date. I have to give notice to the hospital.
Tipton needs that.
Notice to the hospital?
Yes, it's for Boston Medical Center records. I subpoenaed them. I've been trying to get them. I subpoenaed them to grand jury. I've had next of kin sign HIPAA form. I'm asking for a court order for those records.
Larry Tipton is all of us right
I'm
now.
hard pressed to understand why I wouldn't sign the order now.
He's like, are you effing kidding me?
The
My client's
privilege
trial is
holder is
supposed to start
deceased.
October 20th. And Lisa Beatty's been dicking around for years.
Prepare an order and send it to me.
I believe I attached them with my filing.
Do you know what the filing docket number is?
I can,
Lisa Beatty, you might recall,
I
is
just
the
want to
one.
make sure we definitely have it. If we don't have it, the clerk will know.
I can email another one.
Yeah, Ms. Irwin can get in touch with you if we can't find it, and I'll get it signed.
Thank you.
Okay?
Judge, the only other issue, last time we were here, I indicated there was some late discovery in Mr. Johnson's case. I did send a very detailed letter to the prosecutor regarding all of the late discovery. We did have a conversation on Friday regarding that. She's still working through that late discovery. I think we're going to probably have an agreement on what's late, which would include 14 or 15 search warrants and a bunch of other things that seem like it's very similar to the King case. So we will be filing a motion requesting bail, Judge. I just wanted to let the court know that.
All right, we'll see when we get it. Okay, thank you.
Thank you.
these matters are all continued to September 25th at noon. Proctor full issue as requested. Thank you.
Thank you.
Jennifer, I don't have it.
Well, that's that. Too bad, so sad. Hurry up and wait. They've only been in possession of these documents, Proctor's communications, since how long? Oh, yeah, the Karen Reed trial. Something like January of 2024, February of 2024. And it just keeps going and going and going. And it's a good thing that Larry Tipton has filed for an appeal on the suppression issue, the motions to suppress that he made before Judge Frenier to suppress the fruits of the poisonous tree from the cell phone extraction of Brian Walshe, wherein Tipton contends, and I agree, that Buchanan, Garino, and others went outside the scope of the consent agreement between Lynn Beland and Brian Walsh's attorney at the time, Tracy Minor, by extracting the whole entire cell phone. And instead of just looking at the communications between Brian and Anna Walshe, they also looked at Google searches, location data, and that's how they got all of the evidence that they intend to use against Brian Walshe. He has asked the SJC one judge, he's asked for an SJC one judge appeal on that, and that's probably going to take some time. So that may push Brian Walsh's October 20th trial date a little bit anyway. Maybe that's why we didn't see him push back so much. But like Rosemary Scapiccio said, she said, Judge, they were finally able to get the feds to extend this 60-day order. Here's the basics of it. During the Karen Reed trial, the feds turned over a whole bunch of text messages of Michael Proctor's, the lead investigator in the Karen Reed case, and in all of these other cases, including Brian Walshe, Miles King. Miles King, I think, has maybe 2 co-defendants, and there are maybe 2 other cases that none of the attorneys could make it. Rosemary Scapiccio was taking one for the team and standing in for all of the other defense attorneys. All of these other defendants made a motion and said, we're entitled to all this material too, because if Michael Proctor was talking like this about Karen Reed and showing bias for Karen Reed, who's to say he wasn't saying the same thing about our clients? I mean, I'm thinking, do we think Michael Proctor wasn't looking for nudes of Anna Walshe? He was also the lead investigator in the disappearance of Katie McLean, who was manslaughtered because Turk didn't get convicted of anything but manslaughter. Harry Turk, he was also the lead investigator there. They didn't call him at trial. So these defendants are like, we need all of this because he probably said something about our clients too. And so ADA Lisa Beatty, you may remember her because she's the attorney who rubber stamped all of the invoices from Aperture and just paid them without any question. just paid them. It was like $45,000 one month, $75,000 another month, $55,000 another month without any question whatsoever. She paid Aperture over $600,000. And then when one of the witnesses was driving in from Pittsburgh, she was questioning like a bill for a toll. Really? She says, first off, she says, Your Honor, we've been in some conversation with the U.S. Attorney's Office, but on the advice of counsel, that's really all I can say. And Judge Krupp was like, well, there's no hiding the ball here. What are you talking about? And it turns out that what had happened was there was a federal order initially in the Karen Reed case with regard to these federal materials where the feds said you must destroy these materials regarding Proctor within 30 days of the conclusion of the Reed matter. We all know Karen Reed was acquitted on June 18th of 2025. And so they were scheduled to be destroyed on July 18th of 2025. And all of these attorneys were only notified of that something like the night before. So they had to run into court, make an emergency motion. And this has been going on since July 18th. We are now September 15th. So it's almost 60 days. The federal court finally allowed an extension of another 60 days, which Rosemary Scapiccio said, listen, we're another 25 days into this 60-day order, and I don't want to have to come back here in 2 weeks and have them pull the same abada like they've been doing this whole entire time. AKA, they really are trying to hide the ball, Your Honor. And Lisa Beatty said something very interesting using double negatives. I'm not representing to the court that there's nothing to turn over. Meaning, there absolutely is stuff in there that I need to turn over. And I know it because I'm aware of my Brady obligations. And, just waiting for further information from the feds. But no big whoop, no big whoop, no biggie. It's going to take however long it takes because, we're all busy, Judge. What world are we living in? Oh, that's right. The upside down, inside out Narnia of Massachusetts, or Massachusetts. So everyone's been ordered to come back September 25th at noon for another hurry up and wait type conference. And in the meantime, all of these defendants' rights are being violated. In fact, Miles King had to be let out on bail because it was taken so long to get to trial. And then it turned out that the ADA, Lisa Beatty, it was Lally, though, at the time, didn't turn over a whole bunch of search warrants from like however the hell long it was that Miles King was arrested. And then remember, they had started an evidentiary hearing and Lally was on the stand and he was about to be questioned about why he never turned over those search warrants and just turned them over. And then we thought Krupp was like one of the good guys and he was allowing this to happen. And then they called the hearing and then they called it back for another day. And then it was like, yeah, no, we're not going to put Lally back on the stand. And they had somebody, didn't they have Tully or somebody in the hallway also to testify? Right. And meanwhile, Kelsey Fitzsimmons has been returned to jail over there in Salem because of her physical limitations after being shot in the chest by a fellow police officer and undergoing something like 6 surgeries for collapsed lungs and fractured ribs, is unable to physically blow into the scram device that requires her to blow in and test for alcohol 3 times a day. And the grand jury did not indict her on attempted murder. She's charged with assault. And the judge revokes her bail, says, no, I'm not going to agree to urine testing. It was Proctor in the hall waiting. I don't think it was Proctor. Was it Proctor? I don't remember now. I'm conflating so many things. This is so long ago that happened. Yeah, Proctor brought his lawyer with him, right? And he's like, he didn't show up though. Everyone, look at Maggie, was like, I even had Lally hearing written in my planner that day. I know, we were all waiting. We've all been waiting. Right. And they just let that other dude be in the wind who didn't show up for whatever crime he was charged of. And they're like, oh, no worry. He couldn't get here today. So, just have him come back another day. No big whoop. No biggie. And Kelsey is in jail. and unable to see her baby, which was taken away from her without a hearing. So we're getting loud about Kelsey Fitzsimmons. Aidan Carney said on his show last night, he is going to start covering Kelsey Fitzsimmons. He too is outraged. Originally, he wasn't going to cover it because he thought that maybe he would be biased because Bradel also represents Kelsey Fitzsimmons, but you don't have to see you don't have to, there's no bias here because it's obvious what's going on with her. So that's the thing. We're coming back September 25th at noon to see if there's any resolution to this, which I highly doubt because the judge said we'll only be here for 20 minutes. You can easily make it to Suffolk County by 2 p.m. Ms. Scapiccio, who is it was Proctor. Yeah, I don't know. He showed up one time. He didn't show up the other time because remember that hearing was 2 days. What another waste of time. But we were here for it and we got to see some other cases. I have the audio from when Kelsey Fitzsimmons court date, and I did commentary on it Saturday, right after I got home from Boston, and it's in the same stream with the Wilbur review, and it is timestamped for you. So you can go to that exact part if you don't want to hear my review on what we did at the Wilbur on Friday night. You can hear only the court audio of Kelsey Fitzsimmons' horrific revocation of bail hearing, where the judge was just and the judge was worse than I even imagined she would be. Judge Kathleen McCarthy Naiman. And you can hear Kelsey crying at the end when she says, I'm revoking your bail, you're going to jail. And she gets cuffed. And I know that Courtney, Tim Bradel's paralegal, is working around the clock to try and get, medical evidence or whatever. And Bradel filed a motion to reconsider and is going to the SJC. And I saw him on Friday night, and that was a pleasure because I had never met him in person before. And she wasn't even in violation of her conditions, Charlene, you're right. But the judge just threw her right back in jail because it's Salem, where the witch trials were. And it's frightening because it could be you next. Thank you, Gaviling Gloss, for your super chat and your very sweet compliment. And hey, it's me, became a member. Welcome. Amanda says, how do you like to mix your iced coffee? Yum. I use like Italian sweet creamer and ice and coffee, and that's it. Just ice. That's it. That's how I love it. Thanks for asking. Dexter, save us from the Commonwealth. I photographed Taylor Swift's Rhode Island mailman's wedding. I tagged her in my Insta post, but she didn't respond. That's hilarious. Thank you for your super chat. And Monj, first time ever my membership deactivated. Oh, you know what, sweetie? Sometimes if your credit card expires, it deactivates. Or if you were gifted a membership, it will, it doesn't automatically renew. You have to put a credit card in and then it bills you monthly or something. But sometimes that's what happens. So, do the chat with YouTube and just find out what the issue is because that may be an expired credit card. Here's a Rhode Islander. Brigitte, thank you for your super chat. Mike B from the 413. In broad definition, it can apply to ATMs. Okay, so a depository. So he could have broken into the lobby of an ATM, but he also had breaking and entering charges, right? Maybe there was larceny thrown in. I don't know. I'd have to rewind. So thank you very much, Mike B from the 413. What happens to Proctor's job appeal? Mike B also wants to know. I don't know. Isn't there another hearing date? Isn't there another hearing date for him? I don't exactly know when that is. If anybody knows, you can put it in the chat. If anybody wants to go support Kelsey Fitzsimmons, the next hearing date is October 7th, and that is in Salem, Essex Superior. And please wear purple. That is Kelsey's favorite color, and she's asked that everyone wear purple if you choose to go and support, and I know you guys will. I know you will. Yeah, I think it's the end of October, Proctor's job appeal. So that is still continuing. There's already been at least 2 full days of hearings, and there's another one. I'll find out the date, and if we're available that day, we will cover live if we can, if they're broadcasting, which I think they did. And I think the last time we couldn't do it because there was conflict with something else we were covering, or maybe I was traveling. I don't remember. Music to my soul. Tipton made it clear multiple hearings ago that he wanted them to work fast to keep Walsh's trial on time. The judge reassured him then, but now he's appealing the suppression issue, and it might take the SJC a bit of time to hear it. So that may wind up being adjourned anyway. And so that's why, music to my soul, I think that he didn't make a big stink, because we know Larry Tipton, he will make a big stink. Thank you for your super chat. Thank you for your super chat. Purple is her baby's birthstone, says Nicola Maxwell. Oh, that means, oh, that's right. The baby's in February. My birthday's in February, and amethyst is the birthstone. Right. Thanks, Nicola. Hey, it's me, says, I've decided this is not how the judiciary should work. Praise be. Hurry up and reschedule. It's such a waste. I'm outraged. Listen, I know that you guys are seeing this, a lot of you for the first time. I can tell you from my more than 30 years experience in the courtrooms of New York, it's very common. The wheels of justice turn slowly and even slower in civil court. And I'm a civil litigator, and cases drag on for years, and you go in and you waste the whole day waiting for your case to be called, and then nothing happens. There was a judge, who was it that we were watching the other day? Who, if the people were not there for first call, she was issuing warrants. She did not even have a second call. This judge has a second call, meaning he'll call all the cases at 9. And if you're not there, he'll give you some grace and like maybe do a second call at 10, give you a little time in case you're stuck in traffic or whatever. But we watched a courtroom the other day with the female attorney. The female judge, who was like, oh, they're not here. Warrant. She was issuing warrants for everyone's arrest. She was not even giving them a chance to get there. The SJC is the Supreme Judicial Court, Paul Young's Esquire, and that is the appellate court in Massachusetts. Thanks for asking. And so, hey, it's me. I'm here to tell you, it's not unusual. Happens all the time. We just get more outraged about it because we know what goes on in Massachusetts, and we know about Proctor, and we know that from Lisa Beatty, read between the lines, what she said was, there are things I probably need to turn over that I know I need to turn over, but I just need the feds to give me permission to do so. Right. Thank you, Ellen Victoria Olsen, for tuning in from Denmark. Thank you for your super sticker. And Lala72 says, I'm drinking rat poison tea after that. OMG. Oh, don't even joke about that, Lala. Southern Mom, any chance that the judge on Kelsey's case is anti-Turtle Boy and doesn't like Bradel as a result? That judge is awful. Well, I don't know about that, but I will say that she was so much worse than I could have imagined. Please go back. I'm going to change the thumbnail on that stream because the thumbnail is just of the Wilbur. So many people might not know that we also covered Kelsey's case audio, even though it's in the description of the video or the title of the video. Her tone was so horrific. I mean, it was bad, right, you guys? Like, I thought it was going to be bad, but it was so much worse than I could have even imagined, is how bad it was. And here's a picture of her. It was like when Judge Cannoni was shaking with her grave concerns. I mean, you could hear that because we only got an audio recording that they made me pay for. Here she is, Judge McCarthy Naiman. It was so much worse than I imagined her tone would be. And look at the evil eyes. There was no good reason not to let Kelsey just go pee in a cup. And I'm mad about it. Can we get a Dyson Airwrap tutorial sometime? Says Mute. I don't know if anybody would watch that. It's really easy. There's lots of videos on YouTube. Thank you for the super chat. Danny, why couldn't they get the alcohol monitoring ankle bracelet? Because they don't have those in Massachusetts. That's what I said. Because when I was doing my research, when I fell into my rabbit hole, like the Alice in Wonderland that I am, look, I even have an Alice emoji, because I always fall into the hole. The Scram monitor that came up for me was the one they put around your ankle. So it has a dual purpose. It's a GPS monitor, and it's also an alcohol monitor. And it monitors every half hour or so through your perspiration and your ankle. Well, they don't have that one in Massachusetts. But the probation officer did show up to the hearing to say, yeah, there is other ways to do it. We can urine test. And the judge is like, you've made two motions in 3 days. And, she's already been doing this for 3 days. And now you're making a motion? It was like, yeah, she's been trying for 3 days. And it's really painful. It's really painful. And it's cruel and unusual punishment. Oh, and then when Bradel brought up the Constitution, forget it. That's when her ire really came out. Oh, cruel and unusual punishment. And he's like, yeah, the 8th Amendment, then the due process. And oh, due process? Okay, here's what I'm going to do. I'm going to take a few minutes. And she goes off the bench and then she comes back. And what's great about the recording is that we don't have to sit through the breaks because it just picks up where it left off. And She comes back and she had drafted the order while she was back there, because when she came back to the bench, she read the order. And she's like, I'm revoking your bail. And you can hear Kelsey crying, and they're like cuffing her, and it's heartbreaking. So that's the answer to that. They don't have that in Massachusetts. They have this other thing, this other monitor. I'll show it to you. I'll show you what it looks like. But I looked it up to try and find out like how long she had to breathe in this thing. But nowhere on the Scram website could I find any sort of directions of how it's used. Like it was just really weird. Like like there was no way for me to tell how long you had to be blowing into this thing, but I think it's for pretty long. It's called the Scram Remote Breath Pro. Take her down for a minute. And it's a thing that's like this, and you got to blow into this tube. And she has a schedule where she's got to do it at, like, let's say, I forget the exact schedule, 9, 2, and 6 or something. And the judge was all mad about that too. She's like, what do you mean there's a schedule? I said random. And then they went back and looked at the record, and Brado's like, I don't think you said random. It turned out that she didn't say random. So you got to blow into this tube. But it doesn't say anywhere in this website, or I was rushing this morning and I couldn't find it, how long you got to blow into the tube for. But anybody who's had a collapsed lung, hemothorax, pneumothorax, broken ribs, and other injuries such as like that knows that it can be very difficult to keep the breath. Yeah. And CPU Bond 1 says, yeah, and the results go on a website called SoberLink. Iceman says you got to blow deeply, not just a little puff. And you have to do it for a sustained amount of time, right? Someone said how hard and long you have to blow can be adjusted for medical conditions, says Welcher's emotional support laptop. But, you know, they can also have her just go pee in a cup randomly. That would be random. That would help the judge. Says, oops, that she wanted it to be random. So she'd get her random testing. But she's a really mean witch in Salem, which is ironic, but not really. Thanks, Danny, for your super chat. Ms. Holmes, as a civil litigator, would you ever represent a client in a criminal trial? For example, Judge Kathleen McCarthy. Why was she adjudicating that on Kelsey's hearing? Well, she's the judge. So somebody said that she's only heard civil cases before and she's not a criminal attorney, a criminal judge. But I think that when she was in practice, I think she was a criminal defense attorney and also a prosecutor for a period of time. And so as a civil litigator, no, I would not represent clients in a criminal trial unless it was like a traffic matter or something that I could just go in and handle easily. Like lawyers have specialties, all right? And people used to say, can you handle my divorce? Can you write my will? And I would say, listen, would you go to a veterinarian to get your kids stitches? No. Everyone's got a specialty, and that's what you go to them for. And a lot of people should stay in their lane. There are some attorneys that try and do it all, and they just can't because they don't specialize in certain things. They're just taking anything that comes through the door and whoever pays them. And so I don't know what her background as a judge is. And if it was originally assigned to someone else and then it went to her, but it's things that make me want to go, Thanks for your super chat. Hey, it's me. Says, I wasn't sure you'd be able to go past Karen Reed. You've done so much. Many other trials, you've kept me engaged. Thanks for all you do. I don't know what you mean by that. What did you mean? I wasn't capable of handling any other trial, or that I would quit? What are you trying to say? I handled a lot of stuff before Karen Reed. I will handle a lot of stuff after Karen Reed. And here's that. Thanks. You bring me to an interesting point. There was a lot of questions about, like, were you upset? Were you guys upset? Or to Aiden, like, were you upset that Karen Reed didn't show up at the Wilbur to support you? And, were you upset that Karen Reed wasn't there and stuff like this? And he made a post with pictures from the Wilbur. And somebody commented this on his post. When he said this on his show last night, he said it was on my channel. Someone commented it, but it wasn't. It was on his channel. And this person said, and I'm going to give it credit to, it's Ismail Mendoza, 7033, said, it's amazing that you all understand, meaning I guess everyone who performed at the Wilbur, Auntie Deb, Aiden Carney, Mark Betterow, the Glairer, me, Emily C., Nurse Kim, and Tim Bradle also showed up, but he didn't come up on stage. It's amazing that you all understand that it's about you all, not Karen, your passion for justice, your love for what's right. Even if we have different opinions, we still want to know your opinion. You all are who we watch day after day. You guys are our rock stars. We spend hours together. Of course, we want to shout out in public that we love you, trust you, we believe in you all. We don't need Turtle Boy and Karen. We need this. And I thought that that was such a great way to put it, because I think Aiden kind of felt like, oh, the crowd would have been so much bigger if Karen showed up, or if Karen and I did a show together, we could sell out the Boston Garden and stuff like that. But I don't think it was necessary, I don't think it was necessary. I think it would have detracted from it, actually, my opinion. What do you guys think? Right? It wasn't about Karen. Exactly. It wasn't about Karen. Thanks, Mom of a Medic. And if you were at the Wilbur on Friday night, just put a 1 in the chat. I just want to see how many of you were there. Microdots was there too. He didn't go up on stage, but he was there. It was so good to see you, Richie. Jess Machado was there. I met her in the audience. That was so much fun. JFK and James Jackson and Kevy Kev did an outside red carpet show. That was fire. Go watch it. I played some of it on my stream on Saturday night. Jonathan Cummings said I would add to that. Aiden and Karen needed you guys. Y'all are great. Listen, we got turtles to free. I went over a lot of this morning when we went over the probable cause affidavit filled out by Tully to get the phones and all the bullshit that he said, in there. And, oh, thank you, hates me. You didn't offend me. No, people are trolling me all day long. So it wasn't you. I'll pull that up in a second. Heisenberg said, perfect. It is his story and it's sold out. That should be enough. Yeah. That wasn't about Karen. The biggest story here is Aiden's story. That's the story that's going to be interesting when it comes into a movie, or it comes into a TV series or a mini series. It's about a journalist who's willing to risk 60 days in prison to try and get the truth out about a woman that he thought was wrongfully persecuted. Like, the Karen Reed role in the Turtle Boy story doesn't even need to be a huge part. You know what I mean? And he needs our help now. And somebody commented, I can't believe that they didn't give you free tickets and pay for your hotel and all that. That's not what it's about. I'm not there to go for a free ticket and for them to pay for my hotel. I'm going there to support a guy that I think deserves to be supported. So yeah, that was nicely worded, right? And there's a lot of ones in the chat of all people that were there. And it was his night, right? Courtney said, I agree. I wasn't looking for her. It would totally be a different kind of show. And I mean, it was his time to shine and Auntie Deb's time to shine. And boy, did they. Man, they brought the house down. It was so fun. Amy Adams says, yeah, he doesn't need Karen. This is Aiden's time. Oh, this is so perfect. Just another snark in the tank. Debbie Jo says, Karen could have been anybody. Only Turtle Boy could be Turtle Boy. That is so true. That is so true. Right? Scott McGinnis says it was Aiden's night, period, full stop. And Emily C. I forgot Emily C. was there on stage impersonating John DePietro. How could I forget? Because she was the best out of all of us for the roast. Oh my God. You guys go back and watch my recap show if you did not, but Emily C. is a gem. You may remember Emily C. because she is on Twitter and she wrote Hank Brennan's diary entries every day of the Karen Reed second trial. And some of them were from Lally and we read them all. We read all of them and we laughed because if we didn't laugh, we were going to cry. And Emily C. was incredible. And I played her rehearsal stream because there's no real video of what happened at the Wilbur, because what happens at the Wilbur stays at the Wilbur. But because Aiden had a really professional documentary crew backstage filming and in the front filming. And I mean, it's going to be a top-notch production when it comes out. the love in that room was incredible. He will never be convicted of anything. Okay, never. Based on the reception in that room. Minnow said many people stopped reporting on Massachusetts after the Karen Reed verdict. Maybe that's what they mean, as opposed to switching to reporting on more high-profile cases, as some other law tubers have. Yeah, yes, like Donna Adelson, which I told you, and I was frank with you. I couldn't get into it. Don't call me Frank. Don't call me Shirley. Hey, it's me. He says it was a compliment. I've watched all your trials the last year and a half. Karen Reed is just so big. I was calling out your amazing ability. I'm sorry if I offended you. No. I think that other viewer was exactly right, that I would run away from Massachusetts and go to what was popular, like Donna Adelson, which I didn't do because I just couldn't get into it. You know me. Like I pick cases I'm passionate about. I'm not here for the clicks and the views and the likes and the bullshit because I'm too old for that. So thank you. I know that was a compliment, but you should see the way I get trolled. You should see. But I love you. Thank you so much for your super chat. And Ms. Holmes said, thanks, you hit the nail on the head. That's exactly what I meant regarding McCarthy. She's a civil judge, not criminal. I think there's a familiar friend or a friend link. Yeah, there's people digging into it. If there is a link, it will come out. But listen, here's the thing. Justin, and he's got a name that I can't pronounce. It's an unusual, very uncommon name, I think. Aylian, something like that. He's a North Andover firefighter. Files for full custody. Files to take the baby away. Says she's a danger. Here's the thing. If you file for full custody, you don't have to pay child support. Kelsey would have to pay him child support. Let's think about what the agenda could be here, right? Kelsey says she'd never threatened to harm the baby. These other alleged witnesses that said that she threatened to harm the baby and that she was drunk at her bachelorette party may have a personal beef against Kelsey, right? So let's just think about that a little bit. This North Andover firefighter, why he would want to move for full custody. And maybe what's going on in his family. Because things are going to come out that I think, and I don't know what they are, but I'm sure they're going to be explosive. And it's wild. Because it just when you think it can't get any worse, it gets worse. It gets worse. Sheesh. To the sea, says Free Turtle Boy. Free Turtle Boy, he needs our help. He needs our help. Donate to his defense fund if you can, because good legal representation is expensive. And Maeve says this is actually really fun, seeing what a regular court does. They really are fast moving. How many cases do they usually blow through in an afternoon? I think there were a lot of those cases were involving the Walshe case. So there were only maybe 6 cases on the calendar for the afternoon. And so they have a morning calendar, usually at 9, and then an afternoon calendar at 2. And then this judge sometimes puts things on at 12 that he can squeeze in, like what's going to happen on the next Brian Walsh thing. Oh, Michael Marcy's double chin is here and says, stay with me because I'm going to ask you a follow-up to this. For the Scram system, you have to blow like you're blowing into a breathalyzer test, and it takes your picture to confirm it's you blowing into it. I used to work for probation in Bristol County. How long do you have to breathe in for before it will register as a completed test? Because here's what happened with Kelsey. She was blowing into it because she has like the collapsed lungs and like the broken ribs and 6 surgeries in the area where she was shot in the chest. She couldn't do it in order to complete the test. So the test was coming up as incomplete. And so the probation officer said, she's not in violation because she is eventually able to complete the test. And Bradel said she's able to complete it, but not without having 4 hours of pain afterwards because of her conditions. And the judge was like, well, what proof do I have that she's got broken ribs? And we're like, she was in the hospital for 53 days. She's had 6 surgeries. She had to cancel a surgery on Tuesday because the judge wouldn't allow her to go for her surgery without an ankle monitor on because she's a danger to the community. Oh, that's another thing that I wanted to tell you is we're going to take a look at Officer Noonan, who is the guy that apparently it is afraid of Kelsey Fitzsimmons, which is why she's got to be in jail. Let me just see if Michael Marcy's double chin was able to respond to that question. Because every stream we're eventually going to talk about Kelsey. Full lungs, like 30 seconds. Thank you. And then Live Free 7 says, for scram, there's no definitive length of time. You blow until it tells you to stop because that is enough to register a result. Okay. Okay. And Emily C said, time to change Michael Marcy's double chin to triple or quadruple. Yeah. And my Jemmy says in Mike's chat last night, someone was saying his grandfather was a well-known attorney in Boston. Yep. I've heard that. Let me just find you Noonan. And isn't it so fitting that Noonan was like the joke in Caddyshack? Let me find it for you. Big bad Noonan, who's afraid of little Kelsey Fitzsimmons, is here. Tell me if you think he's really afraid of Kelsey Fitzsimmons or if there's something more at play here. I will tell you this. Turns out Kelsey Fitzsimmons did not turn the gun on herself, or that she did actually turn the gun on herself, which we don't know because, you know, they don't have body cam in North Andover, of course, because, you know, they can't afford it. Is North Andover a wealthy community? Does anybody know? Here, my friends, is Officer Noonan. That's Officer Noonan. Full sleeve tattoos. Not that there's anything wrong with that. He looks completely jacked. And I guess, according to this post, which looks like it was on Facebook, North Andover Police Department posted this August 5th, 2024. Chief Gray and the North Andover PD would like to welcome back Officer Pat Noonan to our ranks. Officer Noonan has almost 20 years of police experience between North Andover PD and Lawrence PD. Great to have you back, Officer Noonan. So he came back in August of 2024. He looks pretty big. He looks pretty built. And I don't think he's crying at home that he's afraid of little Kelsey Fitzsimmons. Do you? He's 3 times her size, says Elaine. Very wealthy. You guys are telling me North Andover is very wealthy. She was shot in the chest by Officer Noonan. Because Officer Noonan claims that she turned her gun on him, and she claims she turned her gun on herself because once they took her baby away, she lost the will to live. And then it turns out, I think, that Justin, the baby daddy, showed up to take the baby. Honey and Salt says, don't forget how these 2 officers, Kelsey and Noonan, witnessed an incident where a woman killed her child and herself. Yep, about a year prior. So Noonan's PTSD from that made him overreact. Yep, exactly. He shot her and she's in jail. Yeah, she's charged with, they first charged her with attempted murder. The grand jury failed to indict her on that, but they indicted her on assault with a weapon, which carries 5 years in up to 5 years in jail. And she's back in jail because she can't blow into the tube because he shot her in the chest. She was airlifted to Massachusetts General, where she spent 53 days in the hospital and had at least 6 surgeries. Yep, that's what he looks like. Where's the baby now? I think the baby's with the baby daddy, who wants full custody and probably wants Kelsey to pay him child support. Because, you know, follow the money. The judge has North Andover ties. Yeah, I heard that. Dizzy says, so that's why they didn't think they needed a social worker for the baby, because Justin, I think his name is Justin. Justin was there. Justin. Did I say Jason earlier? I might have. It's disturbing, isn't it? And remember how the judge kept saying during the audio of that hearing that we are here to ensure that Ms. Fitzsimmons is not a danger to the community and officer. We have to, something about rather than incarceration, the thing that's most important is the safety of Officer Noonan and the community. And if she's unable to breathe into the tube and comply with the alcohol monitoring, then she needs to go back to jail. And then Bradle's like, no, I'm not saying she can't do it. I'm just saying it's painful. And she's like, and they cut him off. They cut the hearing off. They just turn off the tape. We do know what Justin looks like, but I'm not sure where I put those pictures, but I'll find them for you in a second. Somebody just told me here that the SJC, thank you, Kyle Sharkey, who is like my man, sending me all the things. This was just published this morning at 10:50 a.m. I wonder if Larry Tipton knows. SJC won't hear appeal to block the Google search evidence at trial. That's wild. Mastad, I know you're here. If that's the one judge panel that said they won't hear it, does that mean the full panel of they can't go further up the chain to the full SJC panel? Does it end there? Give me a second. I'm looking for Justin because we need to see this, because this is hot off the press and that's how we roll. This is on Mass Live, which has everything. Brian Walsh case. SJC won't hear appeal to block the Google search evidence at trial. It has to go to the single justice in order to make it to the full panel. So if the single justice says no, it can't go any further, or it has to go there in order to make it to the full panel. I don't, clarify, please. Yes, there was a court order to take the baby from her. Yes, there was, based on only the testimony of Justin. Amanda says, I'm curious. I saw Justin has a past history of controlled drug in 2013. Oh, really? Does this puke of any testing? No, because he didn't do anything wrong. He got the baby. So let's read this real quick. SJC won't hear the appeal to block the Google search evidence at trial. Here's Brian Walsh. That was on his arraignment of April 27th, 2023. The jail system has not been kind to him. He's had a glow down too. And he's got LC. He had LC cutting his hair in the jail, because Aiden Carney was also in jail at the same time. And LC was the jailhouse barber. And he was also an inmate. And he would give haircuts for $5. And they look like they got their haircut with a hammer. Oh, thank you. So Mastad says, once the single justice denies, the road ends. I don't know that you and I have talked about this, but I really think that those searches should be suppressed. I really think they went outside the consent agreement. I mean, they got to go with the four corners, right? If we go by the four corners rule, the four corners of that agreement between Lynn Beeland and Tracy Minor was pretty damn clear that they were only to search for communications for a 1-week period. All they had to do was get a proper warrant, and they didn't do it. And I'm still mad about it. And I just got the decision, so let's take a look at this. Single justice of the SJC denied an appeal from lawyers representing a man accused of killing then dismembering his wife, who had sought to suppress key Google search evidence at his forthcoming trial. Lawyers for Brian Walsh sought to appeal the decision of a lower court judge that allowed prosecutors to use evidence of those searches in his October trial. They claim police went beyond the terms of a consent agreement when they searched Walsh's phone and 2 tablets belonging to his children. Justice Elizabeth Dewar denied the request to appeal the rulings by Judge Diane Frenier, writing that Walsh could pursue his suppression claims in his direct appeal if convicted. Allowing the motion to appeal would not facilitate the administration of justice. For who? Isn't the defendant the most important part of this justice system? He has to wait to be convicted before he can appeal. And then if the appeal is successful, it will get sent back for a new trial? Welcome to the Upside Down, Inside Out, Narnia, Massachusetts. Here's the order. We like receipts. Thank you, MassDOT. Which actually came down on the 12th. We're just learning about it now on the 15th. Says this order. This matter came before the court, and this is the SJC, which is the appellate court, on the defendant's application for leave to file an interlocutory appeal pursuant to Rule 15, filed on August 25th of 2025. The defendant seeks leave to appeal from two orders of the Superior Court, both dated July 25th, 2025, denying the defendant's motions to suppress evidence obtained from searches conducted pursuant to, one, the defendant's consent to search certain electronic devices, and two, a series of warrants. The defendant timely filed his notice of appeal from the orders and his application to this court. See Rule 15b1. The Commonwealth timely filed an opposition to the application. The defendant's trial is scheduled to begin on October 20th, 2025. The standard for review of applications for leave to appeal pursuant to Rule 15 is whether an interlocutory appeal would facilitate the administration of justice. See Rule 15a2. Upon careful consideration of the judge's two orders, the defendant's application seeking leave to appeal from those orders, and the Commonwealth's opposition thereto, it is ordered that the application be and is hereby denied on the ground that an interlocutory appeal would not facilitate the administration of justice. See Rule 15. The defendant, if convicted, may pursue his suppression claims in his direct appeal. My head's going to pop off again. I need a chiropractor. I met a chiropractor, a lovely woman, at the Encore Casino at the after party on Friday night. And I may need an adjustment very soon. The administration of justice. For who? Brian Walshe is in custody. He's been in custody since his arrest in 2023. Maybe January, February, whenever they arrested him. He's been in the Norfolk County Pokey since then, getting haircuts from LC. But I think LC has been moved and he can't be the barber anymore. If we're going to talk about judicial resources and money that the Commonwealth is spending on trials, because we just went through all of the expenses from the two persecutions of Karen Reed, and I think it was close to like $2 million. Here's the thing. If all of this evidence is suppressed, as I believe that it should be, because I believe in the Constitution and I believe in the Bill of Rights, and I believe in procedure, and I believe that law enforcement should not be able to go outside of a consent agreement and download everything on your phone and then use that to find out where you were and get video and then use that to see your Google searches, and then that all leads towards your guilt. Even if someone is guilty, they still deserve the protections of the Constitution. And it's better for one guilty person to go free than it is for one innocent person to be incarcerated. And there are plenty of innocent people in prison. So they're saying, we're just going to wait. If he's convicted, we'll hear it then, which will mean there'll be two trials instead of one. And that's outrageous, because it could totally change the outcome of the trial without those Google searches and evidence, which are quite frankly the dumbest Google searches known to man. And all of the video of him throwing things in dumpsters all around town, and video of him at Home Depot and Lowe's and Home Goods buying the rug and all that stuff, and the mops and the Tyvek suits. If they waited for a proper warrant, that's all they had to do. But that's how they got the location data, and that's how they got the Google searches. And without that stuff and evidence, he may not be convicted. And so let's just waste more taxpayer money. Obla di, obla da, you don't care about Brian Walsh? Okay, bye. See ya. Thanks for coming. Have a nice day. There's one rule. There's one rule in my chat. Don't be a dick. How about don't be a dick? That's all. It's easy. Oh, and I see your other comments from today, none of which were very nice. Do you know that when you comment in somebody's stream that they can see your entire comment history? All the comments you ever made in a chat come up. We can see them all. We can see your history. Thanks for playing. And so that's that, I guess. Brian Walsh can be convicted. And I guess his trial may start on October 20th, except for Judge Krupp just said they got to come back on September 25th. Because maybe Michael Proctor was looking for nudes of Anna Walsh. Maybe there's some bias there too. So there's that. Crazy Cat Lady said, if Justin didn't want to be with Kelsey anymore, there were definitely better ways to do it. Yeah, but he wouldn't get money that way. Follow the money. Follow the money. Right? They were supposed to get married October 4th. They had a wedding planned. He was very supportive of her postpartum depression journey. He was very supportive. Until what? No, because that's the thing. He's not going free of because of corrupt cops. He's not going to, because they just denied his appeal. They're allowing the evidence in. So he's not going to go free. That's the thing. Obla di obla da, who's now going to try and be nice because I didn't block him. I didn't send him to Block Island or her. Michelle says, my ex is police is PD in neighboring town and knows Noonan and is baffled by this story, but says he's a good cop. Maybe he had PTSD from the horrible thing that they both experienced together. You know, I can see where a judge is, you know, all the judges are afraid of the Lindsay Clancy type situation, right? I can see that. But there are ways of doing this. So that's interesting. Thank you, Michelle. Thank you, Michelle, for your 20. I love you. Without Omaha. Ham sandwich, pizza, and pancakes. Oh my. Says, due to their medical reasons, she can't blow into the breathalyzers and available alternate testing. Is this a violation of rights? She can argue. Yeah, he tried, but they stopped the tape. They cut off the tape. I mean, is it a violation of the ADA? It could be, because she could just go pee in a cup. Like there's an alternative method, but the judge didn't want to hear any of it. So if you didn't listen to the audio from the court, go back to my Saturday night stream. It's the debrief of the Wilbur show. And also we played that towards the end. It's timestamped. You can go right to it. Despite the look on my face, you're still talking. Says it's not a competition. They are intertwining, but distinct perspectives. The woman arrested for a crime she didn't commit. The man who uncovered the story, and the global community who showed up to help. Yes, that is true. And they would all make good stories, right? Thank you for your super chat. CPU Mod 1. I love you. I pray Kelsey gets to see her baby soon. Been here with Melanie since trial 1. She's awesome. She's CPU, Tom CPU's sister, who I also had the pleasure of meeting Friday night. And Tom CPU, I met him again because we have met before. He's amazing. Ms. Holmes, if Noonan had to shoot Kelsey with his experience, why didn't he shoot her in the leg or the foot? Why her chest? Was he shooting to delete her? Makes no sense. I can't answer that. I'm not an expert in police procedure. I've heard a lot of, stories, but if she did shoot her weapon, if she did point her weapon at him, then I think what he did may have been justified. If she pointed it at herself, there may have been other ways to de-escalate. It could be excessive force is what I think. And Bradel has tried to argue that. With the press anyway, not with, because there hasn't been really any hearings in this other than what's happening here. There's also, I think, a probate hearing coming up about the custody. I think that's end of September. Creed says, I'm glad the kid is safe with its father. I wonder why people are commenting like it's the wrong outcome. I don't know how they could hand the baby back to her considering what she did. Is it because Bradel represents her? No, because there's no evidence that Kelsey ever wanted to harm her baby other than this guy's statement to the court that she did say that. And so she has not had an opportunity to be heard. And I think that's the problem. The problem is if Massachusetts can come and take your baby away based on one person's statement, you're all in danger there. Right? That's a problem. Nobody's saying that she should have the baby handed back to her. That's not the issue here. The issue here is the fact that they were able to take the baby away, that 3 of her fellow police officers from North Andover came to serve her with that order to take the baby away and the restraining order. And by the way, Justin also is suing you for full custody without having a proper mental health person with them, without having a social worker, without having somebody who could de-escalate the situation. They went about it the wrong way. And I think that's the problem that we're all having. They didn't show up with a female officer. I think they did it the wrong way. And we don't know what happened because there's no body cam footage because they didn't wear body cams. But the fact that she is charged with several felonies here based on only that officer's observations because they're not listening to her side, that's a problem too. So I think that's what we're seeing here, and we don't like it. But I see what you're trying to say. Beth Allen, if the fiance would put her through this, good thing they aren't getting married. Yeah, I know. It's so sad, horrible to learn the hard way. Amber C said, Kelsey's a perfect example why women would rather battle silently, right, with postpartum depression than speak up and risk losing their baby or having it used against them in the future. Yeah. And that's the other thing too. She was out on leave from the police department because of her postpartum depression. They knew that she suffered from that, and they knew what they were walking into, and they just went about it the wrong way. In my opinion. And that's why we're outraged. Thank you, Amber. And that's a great point. Christine Nursey M says, Kelsey deserves so much credit for recognizing the symptoms of PPD and seeking help on her own. That carries a lot of weight. I agree with you. Le Trepidant says, where was CPS? Where was the social worker? Why was Justin called by the cops to come by? An absolute shit show. So they pinned it on the girl again. And Nicholas says, women do battle silently all the time through fear of losing their baby. Yeah. Yep. Magnolia Gypsy says, it is legally sanctioned kidnapping so that the father does not have to prove his claims and also helps him get custody. He has a vested interest in interfering in her custody by any means. Mother Oates says, remember, it was illegal for Britney Spears to have PPD. She was told her kids were mistakes, and the media laughed as she cried. That's so sad. Oh, Lainey says, yay, chiropractic. Sounds like there were a few there. We have a chiropractic office too. Make sure to drink your water and stay hydrated. It should help too. Awesome. I'm going to actually, it's like 80 degrees outside. I'm going to go jump in the pool. I'm going swimming. So I'm going to peace out to you guys because I need some exercise. I'm going to swim some laps. And I do keep my pool open through October because summer's not over till I say it's over. Mr. Monk's understudy says, how do we actually know Justin is reliable? He was arrested for drugs in 2013 and they just take his word. Where is he living now? Where's the baby all day when he's at work? Who's around the baby? All excellent questions. All excellent questions. And I know that you guys will do a deep dive into that and probably be able to find out. And yes, because Michelle says, but then they found her not to be a danger. Right. This happened on June 30th, I think. She was scheduled to return to work around July 4th. She had been cleared to go back to work. She got her guns back, and then she saw everything flashing before her eyes. Happy Gal says they didn't need to use lethal force on her. You guys are awesome. Thanks for hanging out with me twice today. This is our second meeting today. Thank you, Karen, for thanking me for all of my hard work and dedication. You look amazing. Oh, you're amazing. No, you're amazing. No, you're amazing. No, you are. No, you are. Thank all of you for being interested in this very much. Asian G.I. Joe has a case number here against Kelsey in the state of North Carolina, which I will look up. Thank you for that. I'll come back and look that up later. Thank all of you for donating to Kelsey's fund as well. And you guys are the best. The gaslit the F out of her, says Libby. Make sure you have all your notifications set. Make sure you're still subscribed because YouTube is wonky. Make sure that you, please, I should say, make sure that you have all your notifications set, that they're enabled on your phone and all of the things and stuff like that. Okay? All right. Stay cool, stay kind, stay classy. We'll be back here tomorrow with something else. I'm not sure exactly what we're going to cover yet. Hopefully, it's going to be Bradle and Bettero's mega motion, or maybe we'll have something new to cover on Kelsey. So who knows? Somebody said that Ken Mello is in court today in Fall River. He's been, Just Machado posted that he's listed as an attorney for a trial starting today in Fall River. Well, isn't that interesting? But then somebody said, in response to that, Ken Mello is no longer involved with this case, and he hasn't been for some time. Mass courts probably didn't update on it. So still no proof of life. So we're not sure what to believe at this point because mass lighting is a real thing, as you know, because you've been there. We've all been there together. Thank you, Viola Miller, for becoming a member. I think you're going to like it here. All right, you guys, I'm going to go swimming. I'll talk to you soon. I'll see you tomorrow on something else, probably around the same bat time, same bat channel. Like 10 a.m. is good, 9:30 a.m. I love you with all of my heart. Thank you, moderators, for keeping it classy for 2 shows today because you're amazing. And I love you with all of my heart. And if I don't see you soon, I'm going to die. All right, stay cool, stay kind, stay classy. I know you can do it. I know you guys can do it because 80% of you are not on the cesspool of Twitter. Peace out, everyone. Just be kind. That's a great advice. Thank you. Good night.